If you've ever borrowed money from some of the lenders that are out there and are paying outrageous rates, there's good news for you today. The California Supreme Court has ruled in the case of Dodell versus Cash Call, you're familiar with that name, that an interest rate that is above what would be normal could be deemed to be unconscionable by a trial judge and void the contract. And I know this from personal experience because I had to rule on a case to determine the constitutionality of a statute. There was a claim being made by a lender, and the interest rate was about 99%, and they were trying to collect it. And of course, the defendants raised the question of usury, meaning too high an interest rate. But California has a financial code section that allows any lender after $2,500 to charge whatever rate they want, no matter what. All they need is a license and an agreement. And people who are desperate will sign whatever without even reading it. And so they wanted to enforce it, and the defendant raised the constitutionality of the financial code section. This was part of what's called the summary judgment motion, and I'll talk about that on another YouTube. And I had to decide the constitutionality. I wanted to rule for the consumer. And I remember talking to my research attorney, because we had research attorneys, to look up and see if I could find some way that I could void this contract. There was language talking about unconscionability, meaning if something's unconscionable, it means it's not reasonable, it's not fair, it shouldn't be enforced. And you can do that. And I did on some occasions, but this was a question of the constitutionality. We did the research, and my research attorney's name was Steve. He came up with the cases that said it's perfectly constitutional, so I had to basically find that it was constitutional. I ended up ruling for the consumer anyway because the lender didn't bring in their certificate, a certified record that they had a license. I mean, I wanted to do it, and I did. But today, Dodell said a trial judge can decide if an interest rate is unconscionable, and a 7-0 decision, by the way. And if a judge decides it's unconscionable, like 99%, I've had them as high as 176%, can find it unconscionable and actually set aside the contract. It's now going to wind its way through the Ninth Circuit Court of Appeals because there's some federal issues. But looking at what the rulings are so far, Dodell versus Cash Call, look it up on Google. There may be a way out for you. It looks like some group of people put together a class action, and that's what this is. I haven't delved into the case with a great deal of effort at the moment, but I am going to follow up, and I'll let you know what I find when I find it. So there's still hope out there for you. At least write a letter and take the position it's unconscionable and you're going to resist it if they press you too hard or renegotiate. Anyway, that's it for that subject. I'll let you know later on if something comes up. I'll certainly include it on the show For the People, which is available on iHeartRadio. Looking forward to talking with you again real soon.